Good morning, Your Honor, my co-counsel and defense counsel, and ladies and gentlemen of the jury. This case is before you because on August 24th, 2023, the defendant, Connor Grubb, used deadly force against Takaya Young when he shot through that windshield of her car, ending her life, and by ending her life, ending the life inside of her. The evidence has established that the defendant did shoot and kill Takaya Young. And in this trial, you learned about what happened on August 24th, 2023, in that Kroger parking lot. You've been to the Kroger parking lot. It feels like it was a while ago now. But you've seen the two videos that captured incident in the parking lot. And you've seen the body-worn cameras of both Sergeant Eric Moynihan and the defendant. And many of the facts in this case aren't in dispute. There's no dispute that this happened on August 24th, 2023. And there's no dispute that the shooting happened in Franklin County, Ohio, out at that Kroger, 5991 South Sunbury Road in Westerville. There's also no dispute that the defendant was the one who fired his weapon into the windshield of the Lexus, striking Takaya Young. And the evidence supported that. The state presented the evidence that Officer Ryan Schleve from the Westerville Police Department found the casing, the spent casing in that parking lot. It was eventually marked with a cone, marked with a placard. You also learned from Dr. Harshbarger from the coroner's office that a projectile, a fired bullet, was recovered from the body of Takaya Young during that autopsy. And you learned that Special Agent Tackett collected the firearm of the defendant from him at the Blendon Township Police Department. And then you heard from Andrew McClelland from BCI. He was the firearms examiner. And he explained to you how he took that firearm from the defendant and he compared it to that fired bullet in the autopsy. He compared it to that spent casing in the parking lot, and they came from the same gun. There's also no disputing the objective evidence that was shown to you in the videos that were presented. And these are the 4 videos that came up during this case that you've seen throughout this trial. That Kroger parking lot video, the Kroger walk-up video, and then the body-worn camera videos of the defendant and Sergeant Eric Moynihan. The judge has just read to you the jury instructions, and you will have a copy of those to go back to you with you to the jury room. And he explained to you what charges this defendant has been charged with. And it's easier, I think, sometimes to visually see how those elements play out. So I'm going to start really with the murder counts. Those are counts 3 and 4. And they're based upon the felonious assault counts, which are counts 1 and 2. And remember back in jury selection in voir dire, I talked to you about, maybe you didn't know this at the time, but there are different offenses that meet the same behavior, and the state can charge each of those. And that's what we're talking about here. So you have murders based on different kinds of felonious assaults. So here are counts 3 and 4. The defendant caused the death of Takaya Young as a proximate result of committing or attempting to commit felonious assault. And that is a felony of the first or second degree and an offense of violence. So then you have to talk about the underlying offenses. And what the underlying offense is, that's going to be that felonious assault, which is the count 1 and 2 in the indictment. So to the left, the count 3 murder is based on a felonious assault, serious physical harm. On the right, in count 4, that underlying offense is a felonious assault, deadly weapon. Now let's talk about proximate result. Judge just read this to you, but I want to point it out again. The defendant's responsibility is not limited to the immediate or most obvious result of his act. It is also responsible for the natural and foreseeable consequence or results that follow in the ordinary course of events from the act. So what does that mean? When the defendant shot Takaya Young, that is how she died. It's not an intention to kill, it is a knowing shooting of Takaya. And so that is what the proximate result means. And the doctor explained to you that that's how she died. So let's move on then to the felonious assault counts, which are 1 and 2, and talk about the elements for that. So knowingly applies to both, and the count 1 is cause serious physical harm. Count 2 is cause or attempt to cause physical harm by means of a deadly weapon. In this case, that's going to be that gun to Takaya Young. So the harm is different for each count, but there were about 6 different ways that serious physical harm can be proven. You need to look at B, any physical harm that carries a substantial risk of death. That's the most applicable in this case. We know that she died, and therefore serious physical harm was caused to Takaya Young. And then the other count of felonious assault requires physical harm, which is any injury, illness. Obviously, if we have serious physical harm, we're going to have physical harm. Now, knowingly. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result. You heard from Dr. Harshbarger about how the bullet wound took the life of Takaya Young. And when you shoot the gun, you know what's going to happen when you shoot the gun. That's what knowingly means. And how do you determine it? You can't look into the mind of another person, but you can take the facts and circumstances around it to determine what knowingly is. So the question is, when the defendant pulled the trigger of his gun, did there exist at the time in the mind of the defendant an awareness of the high probability that Takaya Young would suffer serious physical harm? That's going to be the count 1 felonious assault, count 3 murder, or that Takaya Young would suffer physical harm by means of a deadly weapon. And that's count 2 and count 4. And how do we know that? We know that from the defendant's own words. What did he say in his typed statement that was presented in this case? My backdrop was the interior of the suspect's car. My target was the suspect's center mass. So you heard some questions of officers who took the stand. It's not an intent to hurt somebody, is it, when you're shooting for center mass? Please do not get confused over the word of intent, because what the state has to prove to you and has proven to you is knowingly. When you knowingly aim at and shoot at center mass of a person, then you know what the result will be. That's the purpose of your result. And how do we know that that was what the defendant was trying to do? Shoot center mass, cause serious physical harm, or cause or attempt to cause physical harm with that gun? Because where he was aiming. So here's a screenshot from his body-worn camera, and there's Takaya. There's the bullet hole in the windshield. And then to the right is the clothes that Special Agent Tackett recovered from the body of Takaya at the hospital. And look where the hole is. And then you heard from the coroner about that specific injury. He removed that bullet during the autopsy. It entered her lateral left breast. It hit her left rib. It struck her heart. It went through her aorta, which Dr. Harshbarger told you that's a major vessel, and it lodged in her spine. The holes to her heart were fatal in and of themselves, and then the blood loss and the decrease in her blood pressure was also fatal. You also learned that the direction of that bullet was left to right, front to back, and downward. So again, a person has knowledge of circumstances when the person is aware that such circumstances probably exist. You can't say, oh, I didn't intend to kill, I was just stopping the threat. But by stopping the threat, you are knowingly causing serious physical harm. So let's talk about counts 5 and 6, the involuntary manslaughter counts. And this is for the termination of Takaya Young's pregnancy. The judge read to you, it's in your instructions, what termination of a pregnancy means. But yet again, we have the elements of the involuntary manslaughter charges. And these are based upon the approximate result of, again, committing those two different kinds of felonious assault. Count 5, the felonious assault, serious physical harm. Count 6, the felonious assault, deadly weapon. Now, the coroner explained to you that the baby died because of this gunshot wound to Takaya. The baby hadn't died in utero beforehand, and we also know that because in her car was an ultrasound, and that was taken the day before this happened, August 23rd, 2023. And it gave 26 weeks, 2 days. That baby died because of this gunshot and no other reason. Dr. Harshbarger also told you, in his opinion, that fetus was 25 to 28 weeks and there was no evidence of the baby dying before this happened. So just like the approximate result in the first counts of murder, now we have the felonious assault ended the pregnancy of Takaya Young. And I want to point out, in those jury instructions that you have, nowhere in those jury instructions requires the state to prove the defendant knew she was pregnant. That is not something the state has to prove for the counts before you. So, did the state prove beyond a reasonable doubt that the defendant committed the 6 offenses he's charged with? The murder? Yes. The felonious assaults? Yes. The unlawful termination of a pregnancy, involuntary manslaughters? Yes. And so since the state has proven the 6 counts to you beyond a reasonable doubt, then you must move to the affirmative defense of justification in this case. And this is the defendant's burden. Our burden was to prove beyond a reasonable doubt the 6 counts, and now it is the defendant's burden by a preponderance of the evidence to prove to you he was justified in using deadly force against Takaya Young. Here's the definition again. It's in your jury instructions. The greater weight of the evidence. That is, evidence that you believe because it outweighs or overbalances in your minds the evidence opposed to it. And it is a tipping of the scale. This is the legal definition of it. But it is the defendant's burden, and you can consider all the evidence when making this examination. It doesn't matter who produced the evidence, you can evaluate all of it. That's in the jury instructions. But I want to be clear about something when you are going over whether or not the defendant has met the burden. If the weight of the evidence is equally balanced on this issue, or if you're unable to determine which side of the issue has the preponderance, then the defendant has not met his burden, and you must find the defendant guilty. So what comes up in this defense of justification? Well, the use of deadly force, and it is an objective analysis. Reasonableness. The test for reasonableness is an objective one in light of all the facts and circumstances confronting him at the time. But you don't put yourself in his shoes. It's the position of a reasonable officer on the scene. What would a reasonable officer have done? And again, it's only what the defendant knew of at the time. So the question is whether his action was objectively reasonable in light of all the facts and circumstances confronting him, without regard to his underlying intent or motivation. And you've heard about these Graham factors. You've learned more case law in this trial probably than you'll ever learn about again. But those Graham factors were brought up many times during this trial. But you are not limited to the Graham factors. Those are specific things that the law has said you must consider, but that's not what you're limited to. I want to remind you of that. So what do we have? The severity of the crime that officer was addressing, whether Takaya Young posed an immediate threat to the safety of the defendant or others, and was she actively resisting arrest or attempting to evade arrest by flight. So let's talk about some of those. Severity of the crime. We told you from the beginning, Takaya Young stole liquor from that Kroger store. And the Kroger employee had run out and informed Sergeant Moynihan, hey, she stole. That's the information that Sergeant Moynihan would have had at the time. And then the video, the body-worn camera videos of both Moynihan and the defendant show that Officer Grubb would have been in a position to hear Moynihan confronting her about that theft. So that's all the information he would have had when you watched the video. And you heard from Sergeant Eric Moynihan in this trial. He testified in the defense's case. And he told you, I was investigating a theft, and it was a misdemeanor. And he was asked more questions. Well, she wasn't cooperating with you, and she wasn't. There's no disputing. She was not doing what Sergeant Moynihan wanted her to do. She was not getting out of the car. But Sergeant Moynihan told you that's still a misdemeanor. So they are investigating a misdemeanor. Now, the defense wants to make that into a felonious assault or an aggravated robbery, claiming that she's fleeing the scene after taking those liquor bottles. But again, you have to go back to some of the questions asked of even Kevin Davis. This was not a felonious assault, serious physical harm, because the defendant did not suffer serious physical harm. So then the other felonious assault would be she was attempting to cause him harm. What was she doing? Turning her wheel the whole way to the right, away from him. And remember, he's the one who walked in front of the car. But she's turning the whole way away from him. So trying to turn her acts into a felonious assault is a stretch. And the same thing goes for the aggravated robbery claims. They were investigating a misdemeanor theft that maybe turned into the obstruction for not listening and getting out of the car. This isn't about Takaya taking the alcohol. This is about what the defendant did next. When I talk about Takaya turning her wheel, remember the clip of that was played for Kevin Davis. I mean, she went hand over hand over hand. And then you can see in the video, I think it was even paused at times, her wheels are going the whole way. She was going to the right. And this also goes into whether or not then Takaya posed the immediate threat to the safety of the defendant or others. And the state asserts that she wasn't trying to hit him, she was trying to get away from him, which maybe goes into that third factor of trying to evade arrest, but it definitely does not elevate those first two factors. It's not reasonable to stop someone for a theft at all costs. And you heard that Sergeant Eric Moynihan even testified, if she'd gotten away, we wouldn't even be allowed to pursue her. That is the severity of this crime that they were investigating. It was a theft, a misdemeanor theft. Now, you've also heard a lot of law and comments about hindsight. It's in the jury instructions, the issue of 20/20 hindsight. We can't go back with things that we know now and apply that to a decision made earlier. But that does not mean that an officer's claim of justification can't be reviewed. That is what this process is for. That is what you are here for. The state is not saying that the defendant woke up that morning and wanted to discharge his firearm. But the state is saying when he made that decision, it was not a reasonable one, which means it was not a justified shooting. And you are not limited to those Graham factors. And one of the things that goes into your determination of reasonableness in this case is the defendant's own statements. The statements he made at the scene, the statement he made to the medic at the Blendon Township Police Department, that typed statement that was submitted 2 months later, and then there was an email with some follow-up questions and answers, I think a month or so later. So let's talk about the defendant's claim of these injuries to his legs. You heard from Officer Peter Ferguson. He was with the Minerva Park Police Department at the time. And when officer saw him, he told you that he said, "Are you good?" And the defendant said, "It's not mine." There was never a word about any injuries to his legs when Officer Ferguson asked him if he was good. Officer Schleve also testified, and you saw a video of his interaction with the defendant after this shooting. And again, he's asking him, "Are you okay?"
You hurt? I think so.
Westerville fire to all responding.
Is that yours? I'm not sure.
Road, you're clear to enter.
I'm gonna have another medic come just try to check you out. You know, okay? 59. My face is bright.
What did he do when he asked if he's hurt? He looks at his arm. And we know from the evidence that injury would have been caused when he broke that glass in the driver's side door. But he never once looks down at his legs. He never once complains about injuries to legs. But he wants you to believe through some pictures and some expert witnesses that those injuries were caused when he was struck by the car. Well, let's get him to the Blendon.
You hurt?
His own statement, the defendant said 2 months later that when he attempted to get Takaya out of the car started moving forward again and I fell to the ground. So when I was talking to the defense witness, Dr. DeMolin, he never put anything about that in his report. He just made a statement, "Oh, the injuries were caused when he got struck by the car." But he did ultimately admit, okay, it would have been caused or could have been caused when he fell to the ground. And the body-worn camera shows that this happened in addition to these words. So the defendant is taken to the Blendon Township Police Department, comes into contact with Special Agent Tackett. She documents his body, where the camera was, these marks on his legs, injuries to his legs and his arm. And then a paramedic from the Westerville Fire Department also comes, because you heard Officer Schleve say, "I'm going to send a medic to you, just make sure you're okay." And he checks him out. And the defendant says when he was hit to the car, he fell to the ground. But that is not on the video. That's what he claimed that night. That is not what the video shows. But the videos do show that he was able to run back and forth to his cruiser and then run back again when he moved it. No issues with his legs at that time. Facts and circumstances to consider in this reasonableness determination. The video evidence shows Officer Grubb placed himself in front of the car. And you've seen the video of him doing that. It's on all the videos. He walks around Sergeant Moynihan, who is calmly dealing with Takaya, and he puts himself in front of that car. Now, there's also lots of questions about, well, isn't it really important to know it's dangerous out there? And it is. But there was discussion about how, with the change in our laws about carrying weapons in Ohio, officers are concerned there's going to be a lot more guns out there, and that is a risk to their safety. But what does that mean an officer is going to be doing? An officer is going to be watching the hands. Watching the hands. And in this case, from Officer Grubb's position, we can see through his body-worn camera that her hands are right at the top of that steering wheel. So he would be able to see her hands, which means he would be able to see her turning to the right. The body-worn camera of the defendant captures her hand dipping down, and immediately the body-worn camera shows that turn signal go on, and then she's cranking it. And that's something that the defendant's body camera showing what is facing that way captures, but we know he's looking that way because he ultimately shoots Takaya at center mass. The video evidence contradicts the defendant's claims about his feet being completely off the ground, about his waist being on the hood of the car, and his body being carried by the car, the statement to the medic that he was thrown to the ground by the car. What does the video show? It shows him stepping forward and putting his hand on that hood. He steps to the car. He puts his hand on the car. The car is not putting itself on his hand. He is making that decision to advance to the car, put his hand on, and he draws his weapon. That's not consistent with what his statements are. So let's talk about Professor Seth Stoughton. He's a professor at the University of South Carolina Law School. And he is an expert on police practices, use of force. And he talked to you about this case. He explained to you about the practices that he examines as a standard. Now, it was interesting how the defense tried to attack him. But let's talk about his opinions. So, in his opinion, as a scholar on police practices and use of force, that it was the defendant's decision to move to and remain in a position in front of her vehicle, and that it was unreasonable. Contrary to generally accepted police practices, constituted officer-created jeopardy and foreseeably contributed to the shooting of Ms. Young. And second, under the circumstances of this case, his decisions to draw his firearm and to use deadly force instead of removing himself from the path of the vehicle was unreasonable and inconsistent with generally accepted police practices. Now, the defense had Kevin Davis. So they kind of contrast each other. And Kevin Davis told you, I was an officer here. He worked for many years in the state of Ohio, and now he's retired and he's a consultant under use of force. And boy, did the defense go after Seth Stoughton because he was never a police officer in Ohio. But ironically, in that attempt to attack Professor Stoughton's credibility for never being a police officer here, remember when Kevin Davis was introducing himself and his experience, he was telling you how he testifies in lots of different states. So I guess it's good enough for Kevin Davis to testify in other states, even though he's not been an officer in them. Not good enough for Professor Stoughton. You know, it's interesting, when Sergeant Moynihan testified, he talked about how he put his hand on the window, and in opening statement you were told that Sergeant Moynihan was dragged along with this car. But when you take the testimony of Sergeant Moynihan, he said, I could have taken my hand off that window at any time. So that's even inconsistent. He was not dragged by the car. Sergeant Moynihan also told you he was surprised when the shot went off. So clearly he wasn't expecting this to turn into a deadly force situation. And he also did not perceive a threat from Takaya. He told you that. She wasn't a threat to me. But the defendant chose to walk past Sergeant Moynihan, who was trying to take care of the situation, and put himself in front of the car. So Professor Stoughton was asked pretty much directly, like, is it a good idea to step in front of a motor vehicle? What should you do? And he said, don't. But you know who also agrees with that? The Blendon Township Police Department has a policy on it. Now, a policy violation can be used to evaluate this question of reasonableness. And so you were presented with that Blendon Township Police Department use of force. And when feasible, officers should take reasonable steps to move out of the path of an approaching vehicle instead of discharging their firearm at the vehicle or any of its occupants. And it also says shots fired at or from a moving vehicle involve additional considerations and risks and are rarely effective. There's a lot of talk about, well, that was the best place for this contact and cover concept, and there's some disagreement about that too. But by placing yourself in front of a vehicle, you're not going to stop the vehicle. The physical presence of a body does not stop the motor vehicle from going forward. And shooting the driver of the vehicle, again, does not stop that vehicle. In fact, it makes the situation more dangerous because now the driver is out of control. And I think you heard testimony, the car almost becomes like a missile. But Kevin Davis wants you to believe, and other witnesses want to tell you, that it was fine for him to be in front of that car. Now, let me also talk about the defense cross-examination of Professor Stout. He was confronted with this statement here, a little bit small. You don't have any citations in here. You don't have any citations. He tried to explain it's an introductory paragraph. You don't have citations. Show me the citations. But ironically, if you give the whole page of that report, the defense counsel cut off the sentence 2 words short, and then what happened? Citation, citation, citation. Well, that's a little disingenuous in a cross-examination when you didn't even give him the whole quote. And then an attack on anonymous, what is it, rate my professor evaluations? That's what they got? That's what they got to attack Seth Stoughton. None of that at all goes towards the evidence that would support their burden of justification. Now, there was also some attacks on witnesses for being paid. I didn't even ask Dr. Desmolin if he was getting paid. Is it really surprising to you that experts are getting paid for their testimony? I didn't even ask. Of course he's getting paid, all of them. And in fact, Professor Stoughton and Dr. Bauer put their rates in the report so the defense knew what to ask them about, how much their hourly rates were. Again, just another way to try to distract you from what they're going to tell you. Oh, they're getting paid. So were their witnesses for Dr. DeMolin and Kevin Davis. Now, Dr. DeMolin, when he testified from Canada, he came up with this animation the night before, he said, never given to us, to try to show you what happened. And then Dr. Bauer did get a chance to review that before he testified, and he showed you, in contrast to the video, how that animation does not match up with the objective evidence shown on that video. Just another attempt to distract you from what's on the video and what you know to be true. And why do you even need an animation when you have those 4 videos? And then we talk about timing. Dr. DeMolin, the defense wants you to believe this is all this magical, like 1.66 second, snap your fingers decision. But they're not starting the timing when it started. And Professor Stoughton had a chart that was shown to you about timing, and here it is. So the timing from the defendant stepping in front of Takaya's car, 10.467 seconds until he fires his weapon. All right, let's start the clock when he drew his firearm. There are still 4.334 seconds there. But the defense narrows it so much because they need that timing to be smaller. Obviously, if you back up the timing, there's more thought, more chance to get out of the way. It goes to reasonableness. Let's talk about Kevin Davis again. I think he was, whenever talking about getting paid, he charges less than other people, he says. But I think it's kind of interesting, his report, until the weekend before he testified, had the wrong defendant's name in it and the wrong victim's name in it. That's curious. So Dr. Jeremy Bauer, he's looking at this question of reasonableness of the acts in a scientific way. Human performance, the biomechanics of the body, the car, and he synced the videos like Kevin Davis and Seth Stoughton also did. But he went through that video to show you the actions are not consistent with the defendant's statement. And here it is. 2 months later, in a typed statement, he said, "My feet were completely off the ground, my waist was on the hood of the car, and my body was being carried by the car as she continued accelerating." The simulation, the animation might attempt to show you that, but the videos do not. And when Dr. Bauer played it for you, is the cropped up version, you can see him step forward. Are we on? No? Okay. So take a look here. The one on the right. What do we see? We have Officer Grubb in front of that car. He steps forward and puts his hand on the car. Again, he is approaching and making contact with that car, not the other way around. defendant's statement, it's also important to know that he said he had watched the body-worn camera prior to making his statement, and he still wasn't able to.
Objection, Your Honor.
Take,
Absolutely.
That is.
100%.
approach. Well, the objection is sustained, and ladies and gentlemen, closing arguments are not evidence. You've heard all the evidence, and it's just a guide by the attorneys.
And so,
Doesn't change my thing. You can read whatever you want.
all right, I'm going to read it then. So,
Same objection, Your Honor.
in the statement of Officer Connor Grubb that was submitted to you as evidence, it's typed, "I have now had an opportunity to review the body-worn camera footage of the incident." Those are his words in the statement.
And absolutely, Your Honor, that does not mean that he saw it before he wrote a statement.
Note your objection.
Strike that word, Your Honor.
Overruled.
The defense has not presented sufficient evidence to meet the burden of preponderance of the evidence, even at the standard it is. Their witnesses and the evidence heard in this case does not get them there. And because the evidence does not support their burden of justification, you must find the defendant guilty of the murders and the felonious assaults and the involuntary manslaughters.